How can a provisional patent application waste money? Imagine inventing something new and exciting, then rushing to file a patent to protect it. But not every step in that process saves you money or helps your invention. Let's explore how a provisional patent application can end up costing you more than you think. A provisional patent application is meant to be a quick, low-cost way to secure an early filing date. It doesn't require formal claims or a detailed legal description, and the filing fee is much lower than a full patent application. But if you're not careful, it can turn into a money pit. First, if you rush into filing a provisional without preparing a thorough description, you might end up with an incomplete or vague document. This means when you file the non-provisional later, you may need to start from scratch. That doubles your legal costs and eats into any savings you hope to get. Another way money gets wasted is by not fully describing your invention in the provisional. If the disclosure is too brief or unclear, the later non-provisional application might not get the same priority date. This weakens your patent rights and could make your invention vulnerable to competitors. Spending money on a provisional that doesn't support your claims is like building on shaky ground. You also need to remember that the United States Patent and Trademark Office does not examine provisional applications. That means there's no guarantee your invention is patentable or that the provisional is legally sound. If you later find out your invention isn't eligible for a patent, all the money spent on the provisional is lost. You might have paid for two filings and still end up empty-handed. Timing is critical with provisional applications. They only last for 1 year. If you miss the deadline to file a non-provisional application, your provisional expires. All the money spent on it goes down the drain, and you lose your priority date. That can be a costly mistake if you have to start over with a new filing. Some inventors believe that filing a provisional gives them strong legal protection. But that's not true. A provisional does not grant enforceable rights or stop others from copying your idea. Relying on it as a shield can lead to wasted resources and missed opportunities. In the end, a provisional patent application can waste money if it's poorly drafted, if it leads to unnecessary duplicate filings, or if it's not followed up with a proper non-provisional application before the deadline. To avoid these pitfalls, it's best to plan carefully, work with a patent professional, and understand that this tool is just part of a bigger strategy. Proper use can save you money, but careless use can drain your resources without giving you the protection you need.